Good evening, everybody, and welcome to Fair Housing is the Law. I'm your co-host, Michael Smith, and I'm with your host, MJ Borelli. How you doing, MJ?
I'm doing fine. I know I was the host. We're with the Fair Housing Council of Central California, and our mission is to try to end segregated neighborhoods and housing discrimination here in Central California.
Yes. So today we're here, and we're going to put out discuss one or two new laws that have passed that I'm pretty sure y'all are interested in for those that are out here renting here in Central Valley, Fresno. And one of them would be, let's get started. A lot of people out there, I know y'all have been paying security deposits, and a lot of people have been paying 2 months security deposit up to 4 month security deposits. But a law has changed. I don't know if it's January 1st or in April.
These are California state laws that have gone into effect January 1 for some of the housing stuff that's been added to either the California Civil Code or the Fair Employment and Housing Act. And just a little sidebar here, the Fair Housing Council of Central California, we do not necessarily enforce or seek to enforce California state laws. What our body of complaints surround housing discrimination, but often those folks who are experiencing housing discrimination also may have landlords or property managers who are violating state laws as well. And one of the things that Mike was just talking about, security deposits, now a landlord, or if you're a home seeker looking for a place to rent, no more than 1 month's rent can be assessed by landlords anymore in California. Now this pertains to certain types of rental housing, and there's going to be some exemptions here for some landlords, depending on the situation. But I know I was just talking to a party maybe 2 hours before this broadcast where the tenants were assessed a 4-month deposit. In other words, their rent is $1,000 a month, so the landlord wanted $4,000 up front plus another $1,000 for the first month's rent. And these kinds of things are illegal now. Now, I've been hearing about landlords and property management companies that have been overcharging in this area. There were already statutes in place where these excessive kinds of deposits couldn't be assessed. But, and the interesting thing about some of these civil codes is that they don't get enforced, or enforcement involves maybe the tenant or the home seeker going out and retaining an attorney, which is going to cost them a lot of money, probably more than the deposits that might be assessed. But at any rate, right now, landlords cannot charge more than 1 month's rent. So if the rent is, $1,500, you can't charge more than $1,500 for the deposit.
Oh, that's good news. That's good news. So we could fairly say, is it safe to say it's the law now?
It's the law. It was passed by the California State Legislature last year, and it's the law. Okay, whether or not it's going to get enforced, sometimes that's going to be you as a home seeker if these kinds of problems arise. Certainly you can call us, and I think our number is kind of going to be flashed on the screen here. 559-244-2950. We'll refer you to some folks that might give you additional advice. But basically, landlords can't charge more than the month's rent in terms of the deposit.
That's great news. So, like you were saying, the phone number is there. So, is that their best way of defending against that? If it happens from this point on and you get charged more than 1 month's deposit, what would be the route that they should take?
The problem is when you read the statute, you're not seeing too many remedies for enforcement. Actually, I'm not seeing any remedies for enforcement. You could try to go after the landlord with an attorney, but once again, a lot of laws are going to have these, remedies on what to do when in this case, the landlord isn't following the law. But these particular laws don't really give those remedies. There are other new laws that take effect in terms of, these are sort of source of income issues that have to do with people that have subsidized housing, like Section 8 housing choice vouchers, wherein there's a few things that, for example, in California, this has been in effect for already a couple of years, and some more stuff was kind of added that goes into effect this year, where if you had a Section 8 voucher, landlords have to take it in California. They can't refuse your voucher as long as you're, the housing authorities who, in counties and cities across California, they're the ones that administer these vouchers and set up contracts with prospective landlords to pay a portion of the tenant's rent. So landlords can no longer refuse to rent to folks who have a Section 8 voucher. Now that stuff's already been in effect for a couple of years, but a new thing was added. I think you could kind of talk about credit history.
Yes.
And folks that have, specifically, folks that have Section 8 vouchers.
They're supposed to no longer check your credit history or use your credit history to determine whether they're going to allow you to move in or not?
They can check your credit history. There's all kinds of laws and rules that allow that. But they can no longer refuse to rent to you if you have a voucher or any other kind of subsidy that the state or federal government might be giving you in order to get housing. They can't refuse you based on your credit if you can show your ability to pay the rent, whatever your portion is. Now, those of you who understand how this, or the viewers that might understand the Section 8 program, there's an eligibility that's based on income and family size that determines whether or not you can get one of these vouchers from a local housing authorities. Generally, these are assigned to folks who are low to moderate income in terms of their family size and whatever their source of income is. Now, keep in mind, California has had a statute in place for many years that makes it illegal for landlords to refuse to rent to you because of your source of income. And having that Section 8 housing choice voucher might be construed as a source of income. So therefore, landlords can't refuse to take your Section 8 voucher. Although we sure have a lot of landlords out there who are either ignorant of this, which they shouldn't be, or they're sort of digging their heels in and deciding, I don't want to rent to folks who have Section 8 vouchers. So agencies like ours have been spreading the word about this for a couple of years, and landlords are now kind of getting the idea that, you could try a case based on FEHA, the Fair Employment and Housing Act, where there are some remedies for enforcement within that law. It's a civil rights law, and it's administered by what used to be the Fair Employment and Housing Department, which has now been renamed and kind of shrouded in mystery as the Civil Rights Department for the state of California. I think they're still getting their trip together, so to speak. It's difficult to contact them, but you can reach them online if you have this kind of a claim where a landlord doesn't want to rent to you because you're a Section 8 voucher now. So, landlords are getting the idea, can't discriminate against a guy because he's got a Section 8 voucher. So maybe we'll try credit history so that we don't have to rent to these people. Generally speaking, and if you look at the statistics, and the history of poor people, you're going to find that those folks might have the lower credit scores for a whole variety of reasons. Only makes sense. And now you can't use that against folks that are carrying around the housing choice voucher, the Section 8 voucher. Now, it's kind of interesting because it's kind of confusing when you read this law. You have to remember that really the purpose of a credit history is to determine whether or not you have the ability to pay the rent. So traditionally, landlords would look and see, geez, this person sure has a lot of debt here, and maybe there's not enough left, of their income at the end of the month to pay the rent. So that's really what this was supposed to do as a tool for landlords to determine who they want to rent to. But it seems that a lot of us have all kinds of little dings on our credit, regardless of our income, even if you have a higher income. But this can't be used against a person who has a Section 8 voucher. And what I'm seeing happening, because we've been getting some calls about this since January 1st, and here it is. This broadcast is, 2/3 of the way through the month almost. And already landlords, you got bad credit, so we're not going to rent to you. And it's really becoming what I believe to be another tool to not rent to folks who have Section 8. And why is it that people don't want to rent to folks who have Section 8? The government's going to pay part of the rent. You're always guaranteed, at least some of the rent, is going to get paid. So why is it the landlords don't want to rent to folks who have Section 8 vouchers?
Well, a lot of is the word stigmas.
Yeah, stigma.
A lot of stigmas that come with the Section 8 thing is the people that have Section 8 are not the type of tenants that you would want in your property. Some people feel that you got Section 8, you probably got a lot of kids, they're gonna tear up my property. And I think that's the stigma that goes with that.
And some of that is mythical, because all kinds of folks might be eligible to have a Section 8 housing choice voucher. Sometimes senior citizens have them. And, they're just a person alone trying to rent a unit. All kinds of people. Remember, this eligibility is based on your income and your family size. And we're looking at what the government determines to be a median income for any specific area in the state, because it's going to vary from county to county what median incomes are. And, if you're below that median income, you might just be eligible for this housing subsidy, which is kind of a cool thing. But let's get down and dirty what the real reasons are. And that is that historically and statistically, and if you look at the data today, it's the same as it was pretty much 20, 30 years ago. And that is people of color tend to be the folks in the majority that have Section 8 housing choice vouchers. So from a fair housing standpoint, and when I'm talking about fair housing, I'm talking about the Fair Housing Act, which prohibits discrimination by landlords, i.e., refusal to rent to somebody because of either race, color, national origin, religion, gender, disability, the fact that you got minor children in the household, which is called familial status. And often you're going to have, all kinds of mixed and extended families within a Section 8 family that share a voucher. And we believe, based on the data and what we have seen in the course of investigations that we do in regard to folks that believe they're victims of housing discrimination, a lot of times these are Section 8 folks. And there is this myth that, I can't rent to these people of color because, well, they're just not good householders. And that's called housing discrimination. So you kind of full circle back to some of these new laws that are taking effect. And have taken 2 years for people to get the message, like in the case of Section 8 vouchers, that we're trying to change the playing field for people out there who are home seekers.
Yes, and that was part of the reason for the very expensive deposit, because a lot of home renters, they're trying to find the best, and that, as they say, the best people to live in their property. So if they charge you 4 times the rent on the deposit, then that kind of lets them know, like, okay, this person has some money, ain't gonna have no trouble out of this situation right here.
Well, of course, assessing a big deposit. Also, this mythological thinking that people of color aren't going to pay the rent, or people that have a lot of kids, or people who are receiving welfare benefits are not necessarily good tenants. These are all the kinds of stigma that Mike is talking about. And, and I've certainly heard and been in discussions with landlords about this for 25 years that, I don't want to rent to those people. And this is what they mean. Now, also, there's a prohibition in the Fair Housing Act about imposing different rules for different people in terms of, looking for a place to live, so that some folks might have been in the past assessed 4 times the rent in order to live here. And you can't do that with a Section 8 voucher. You have to look at what the person's, what we call HAP payment, their portion of the rent, which is probably going to be substantially less in the entire rent. The other portion of the rent is paid for by the administrator of the housing choice vouchers. Most of the time that's going to be a housing authority. And there's housing authorities all over California in just about every county. And they administer these Section 8 programs. But all of these tools, credit history, assessing these huge, 4 times the rent. I mean, if I'm, I have a job, I've been working for most of my life, and a lot of places that I go, I certainly couldn't, I don't make 4 times the rent. I don't think the average person, looking at the average rent in Fresno for like a 2-bedroom apartment, is going to be anywhere from $1,800 a month on up, that a lot of folks don't have 4 times that. So how is it that they get to rent the apartment, and these other people of color who are disabled or who have a lot of kids, they just get right at the get-go turned down? Well, you're not making 4 times the rent. But this other guy gets an apartment. Maybe he doesn't make 4 times the rent, but the landlord says, we're going to let you in anyway. That's different rules for different people. And if a landlord or a property group is doing this, imposing these different rules for different people, and if they're doing it because of race, color, national origin, etc., then they're in violation of federal law. And all kinds of things can happen. These are civil claims, so the police aren't going to come and get you. But fair housing agencies like ours will sue you in federal district court for damages to those clients. And also a little sidebar here, those kinds of lawsuits average out from initial filing just a summary judgment in the neighborhood of anywhere between $80,000 to $400,000.
So it's not worth it.
And that's before it's even hit trial. So
your renter is not worth it.
Well, breaking the law is not worth it, because you're going to get caught, and you're going to get, you could have a judgment against you for not only, you got to pay your as the guy on the other side, as the respondent landlord, you're going to have to pay your own attorney's attorney fees plus court costs, and as well as the guy that's suing you, the tenant that says you discriminated against him. You're going to be liable for compensatory damages, attorney fees, and court costs. And sometimes the courts can And some of these housing discrimination cases also award punitive damages. I've seen all kinds of things happen when landlords don't do the right thing. I've seen judges bar landlords from property management from even being a property manager for periods of time. I saw a case down in Kern County a few years back where it was actually a sex harassment case under the Fair Housing Act along with gender discrimination. And the judge put the landlord's property into receivership, really barred them from being a landlord. I mean, you know, the courts can do some pretty radical things. So it's not a good idea to think that, well, I'm just not going to obey these rules. So if these kinds of things are happening to you, you have to be listening to this, watching this, live streaming it, whatever you do. And this might be some of these things may be happening to you or people that you know. Get in touch with us. We're probably the best folks to handle these kinds of questions and or what do we do about it when it actually happens to us. Now, a lot of people believe that you make a claim and say, you know, this landlord, he's racist and he did this to me. And right then and there, you know, punishment awaits. But we investigate to determine whether or not there's any credence to the claim. So what we're looking for is evidence that landlords are doing this. And if there is evidence that substantiates these kinds of claims, then we can go forward with these other legal remedies.
Okay. I know of one thing that I've been hearing out there. A lot of landlords, they don't like to deal with Section 8 also because they have to do a lot of repairs. Everything got to be up to code, and being a slumlord is profitable. You do have slumlords, that's a real thing.
Oh, yeah.
So you got some people that specialize in that.
Oh, yeah.
And so they'd rather not have no ties or have to deal with any government or nothing like that.
Well, let's be frank. There's a lot of cities and counties that don't even enforce findings of code enforcement. You know, the state also has, state of California, as many other states, certain habitability standards for rentals. And this applies to apartments or houses or mobile homes. And those kinds of landlords that have this substandard, non-habitable rentals, and we talk to lots of people who are victims of slumlords, there's a whole set of laws with very, very specific remedies on enforcement, which is fortunate in terms of habitability, because there's lots of folks living, you know, as cold as it's been. We've talked to folks who haven't had heat the whole time they've been renting places, and sometimes we're talking years, much less air conditioning in the summer, which is not necessarily covered under state habitability rules, but heat is. Access to hot water, and of course, you know, adequate plumbing, no leaks, and no vermin, no mice, no cockroaches, all those kinds of things tap against California habitability rules in terms of rental housing. And I know that cities from time to time make a stand that, oh, you know, we're going to go after all these slumlords. I think a few years ago, the city of Fresno put together a landlord's registry, and I don't know if that's still in effect, but it looked like they were maybe going to go after landlords who had substandard housing. Now, Section 8 folks are guaranteed under federal rule that they should have decent and affordable housing, but it's all dependent on the findings of the local housing authority and the inspectors they send out to inspect these rental properties to make sure that they're going to be okay with the Section 8 program. But, you know, I know we're involved with some problems against housing authorities in a Central Valley County. It's not Fresno County. Because sometimes sometimes you've got a rogue inspector and they're not doing what they're supposed to do, or the participant doesn't want to tell the inspector that something doesn't work right, or, I actually really have bugs and I just sprayed before you came over to inspect. And they don't want to tell the housing authorities inspectors of problems that maybe the inspector wouldn't find on their own. It's not a good thing to do that. You are guaranteed safe, decent, and affordable housing under the Section 8 program. And these are federal regulations. So you're not doing anybody any favors, including yourself as a tenant, if you're not expressing some of these anomalies or problems with the housing choice inspector. And one of the things that you hear a lot about this time of the year is no heat. And I was talking to a caller at our offices for the Fair Housing Council just the other day, and this person has not had heat for the entire winter, when it starts to get cold here, end of October, November, December right now. And I don't think it would be very comfortable in my place without any kinds of heat.
Most likely they're keeping the stove on in that situation.
And that's causing, that costs a higher PG&E bill. And so, a lot of people do that. I know people that will even run hot water in the bathroom to try to get a little steam going to warm themselves. Now, you don't have to deal with this kind of thing. Call us. We'll tell you what to do at the Fair Housing Council of Central California. Otherwise, if you don't want to call us, call your city or county. Ask for your code enforcement division. If you happen to live in a county that, maybe doesn't have one, or a city that doesn't have one, most do. Sometimes they give them different names. And then talk to the city manager of whatever city that is. And hopefully you're going to get directed to somebody who's going to come out and inspect. And if they find these kinds of problems, that no heat, leaks in the roof, insects, mice, plumbing that's faulty, wiring that's faulty, these things are all against the law under California rule, and generally they're against the law under local codes, local housing codes as well. And the process generally is, if the local government entity like a city sends out an inspector on a complaint like this, they're going to be required to serve notice to the owner, and they're going to give a window of time to the owner to make the repair. And sometimes the repairs are beyond repair, and code enforcement, I've seen code enforcement here, actually, what do they call it, red tag buildings. And when that happens, generally the tenants have very little time to get out of a building that's been red tagged as like a building that's been condemned. And you don't want to be there. And those people who are receiving housing subsidies through Section 8, and they don't tell their housing authorities when something happens like their heater breaks, and they don't want to tell anybody because they're afraid they're going to lose their housing, but you need to, because you're guaranteed safe, decent, and affordable housing. It's exactly how it says it in the law. And you need to call your local housing authorities when that happens. And if all else fails, call us, and we can help you contact your local housing authority. If
We
that's
got
what's
your
going
back.
on. Yes, basically. And, one of the things, too, I think people don't get is that the Fair Housing Act, which is what we facilitate enforcement of, is not just for people on Section 8. It's not just for poor people. It's not just for people of color. This is a law for, it could be anybody. regardless of your color, because this is a protection against, race, national origin, and your color, disability, gender, religion. It covers a lot of areas where landlords might discriminate against you and keep you from having the housing of your choice. Really, that's what the Fair Housing Act is all about, is underlining that you have a choice in where you want to live. You don't have to be relegated if you have a Section 8 voucher to a ghetto area of town. That Section 8 voucher has to be honored any place. And I know that this is a big deal for us at the Fair Housing Council for years. I know, and we're not alone, because there's other fair housing councils in California. There's lots of fair housing councils across the United States, and we all have been pushing at housing authorities and HUD that make the regulations and rules about how these programs work, that we've got to get people out of these crappy neighborhoods, and they need to be able to go to a neighborhood that they want to go to, that has schools they want to send their children to, etc. Because unfortunately, not all neighborhoods are equal, in case you haven't noticed. This is why, oh yeah, that's a bad area over there because the housing's run down, doesn't have the pretty green lawns as other parts of town. And that's an indicator that, maybe people aren't getting the same housing opportunities in one section of town as the other. And this, quite frankly, is called housing segregation and housing discrimination. And we start looking into this and finding out if that indeed is what's going on, then we can look for remedies for folks.
Now, another law that I was looking at, I have to look into it more. I don't quite understand it, but it was saying that now they can't evict tenants due to criminal activity. They can't evict tenants due to criminal activity anymore. What does do you know?
Well,
what that
no,
means?
yeah, they can. I mean, if you're a tenant and you're doing something illegal on the property, let's get extreme. You've got a meth lab in the kitchen, for
Selling
example.
dope out your house or something.
Yes. If you're engaged in some sort of illegal activity, landlords, of course, can still seek to evict you. But what this is talking about is criminal backgrounds. When you do a credit check, and remember, folks, we live in a digital age where pretty much everything is discoverable. If there was a record of it somewhere, you probably are going to find it on the internet. I get people that call me all the time, well, when is this eviction going to go off my record? When is this court eviction going to go off my record? And the answer is never. And it's the same thing with criminal history. A lot of people believe that, I could have all this stuff expunged from my record, and that's just not the case. Very, very special circumstances surrounding, on a case-by-case basis, those folks who have been successful in having certain things expunged from their record. And it's terrible, but we all have a record out there of something. Whether it be credit history or whatever. And a lot of times when these property groups or landlords are running credit histories, they're also running criminal background checks. Sometimes these services come in a package if they're using a specific company to do it for them. But, on your own without any company, you can certainly, as a landlord, search legal records and property records and credit history, for that matter. Now, everybody needs a place to live. Criminal history, to me, seems like kind of an iffy standard there. When, on the one hand, we got to do something about this homeless population, et cetera, et cetera. And there are many folks out there that are sleeping rough on the streets that might have some criminal history background, be it misdemeanors or felonies. Now, the federal government, if they're funding housing, HUD housing, I think people used to call it, project-based Section 8s generally are what they are. And they have had a prohibition up until a few years ago. HUD is kind of rethinking this. On anybody that had criminal history. Then that was amended to people who had a violent criminal history. In other words, you looked at the criminal history and they had things like assault or murder or manslaughter, violent crimes, or drug offenses. The government has a particular little bug about drug offenses, illegal drugs. So those people would be barred from public housing, could be barred from public housing. And, of course, mainstream landlords sometimes have a policy where they're not going to rent to folks who have any kind of criminal history. And this is another thing. It needs to change, and it is kind of changing little by little, year by year. HUD left it up to local housing authorities and their public housing properties to kind of weigh out an individual's criminal history background. Like, how long ago did it happen? And, were there any repeat offenses, or how are they doing in the community now? That kind of thing. Once again, criminal history, like credit history, just screams racial disparity. Let's get real. We hear about this all the time. The folks that are incarcerated tend to be a huge percentage of folks of color and other nationalities. So, once again, it is another tool. It is another tool to limit a person's housing choice, and it's another tool for housing discrimination across the board. So, less and less so. Now, there's already a law in the Fair Employment and Housing Act that prohibits arbitrary discrimination by a landlord. What does that mean? And it could, one could argue that, I'm not going to rent to folks because they have any kind of criminal background. In subsidized housing, and I certainly know of a lot of people living in subsidized housing that do have criminal backgrounds that may even include violent crime and or drugs. One of the things that might put another light on, and know if you, even as a home seeker, you want to share this, or whether or not you're if it's a drug-related criminal background, are you in some kind of a recovery program, or did you participate in a recovery program? Those are kind of personal things, but you could possibly share those kinds of things with the prospective landlord. Personally, I think that weeding somebody out because of their criminal background, I would argue, is housing discrimination. But it's not necessarily going to be accepted that way in every single case.
Now, on the other hand, I was hearing about churches and non-profit colleges will now be able to build affordable housing on their property now. Did you hear anything about that?
Well, affordable housing, which is one of my big pet, because there's almost no such thing.
You got to do this. Affordable housing.
Affordable housing with quotation marks. That's a whole other program that we could talk about maybe the next time we're on the air, what affordable housing is and what it isn't. And 9 times out of 10, it's not affordable. But your question was...
But they said that churches and
so it's not,
nonprofit colleges will be able to build on
sure,
their property
sure,
now.
they can do that anyway. They could do that before. They could do that under the Bush administration. If there were federal funds available for, general public out there, faith-based organizations could access them, and certainly low-income tax credit allocations might fall into that category, as well as HUD funds for building. Yeah, they can do it. Now, what they can't do is if it's public funds, they can't limit the tenant population, the future tenant population, to members of their faith only, because that would be housing discrimination based upon religion.
So I wanted to do. Is there any way that like shelters could fall under fair housing law?
Yeah, they do all the time. Generally speaking, fair housing claims have to do with a specific dwelling. But really, it's about any kind of housing situation. And yes, shelters, for example, that discriminate, this is a big deal right now, that discriminate against people because of their gender identification, for example. Or shelters who are denying access to a shelter because a person's disabled, or because the disabled person might have a service or assistance animal. So you're seeing changes with some of these shelters. I've seen lots of lawsuits over the years.
Some shelters
against
require
shelters.
you to attend church.
This is a good one. That that is interesting because that's been tried in different places. My personal view on that is it could be a violation of the Fair Housing Act based on religion. In other words, you might be denied housing because you didn't participate in the church service. And this used to be really common with rescue missions, etc. If those kinds of organizations that are seeking to help homeless people, houseless people, or people that just need a shelter because of spousal abuse or any other kind of thing like that, if they're receiving public funds, they can't do that. Basically, taxpayer funds, no, you can't do that. Now, if you just are on your own and I'm, such and such church and I have a shelter, but I'm not receiving any public funds, I might be able to do that. If you don't go to church and do this thing according to our particular faith, then we're not going to give you any housing. If they're not receiving any kinds of public funds, you probably can go ahead and do that. Now, one example is I had a case against a tax credit housing development in Tulare County. Actually, it was in an unincorporated area called Ivanhoe, and this was about 4 years ago. And it involved a landlord. There was a specific eligibility to live in this apartment complex that was built in an unincorporated area of Tulare County, which had a high population of farm workers and people that were really poor. So this landlord would tell prospective tenants, and then even folks after they were accepted as a tenant, that they needed to go to his church, and that his church often did services in the public room that they had, kind of a rec room that they had at the complex. And this was a real problem for the complainant that contacted us. They had their own religion. They were a Roman Catholic couple, and they were expected to renounce that and join this other church that, I don't know what it was, some sort of a Protestant congregation. And they sued the landlord on the basis of discrimination by virtue of religion. So if that development that you're talking about to do affordable housing, and I'm going to say right now, if you're doing affordable housing, there's going to be some federal rules involved with what affordable housing is when you were using that term. So you're not going to be able to bar folks because of their race, color, national origin, religion, gender, disability, or family status, just like any other housing provider.
What is, for the listeners out there, what is a tax credit housing?
Well, we need a whole program for that because that's the whole basis of this phrase we hear all the time, affordable housing. Low-income tax credit housing. What this is a tax credit against income. It's actually in the Internal Revenue Code, under Section 42 of the Internal Revenue Code, that allows for housing developers to receive tax credits by providing below market rate rents for what the feds deem as eligible tenants or eligible home seekers. So generally, there's income and family size involved, but it's different than Section 8. And what happens is the developer of the housing, the owners of the housing, a lot of times these are nonprofits or churches. I can think of one organization, Silvercrest, which is part of, the bell ringers at Christmas time, the Salvation Army. They have a whole housing division, and they have affordable housing all over the country for seniors and or families. And a lot of that is low-income housing tax credits that are involved with that, too. So the way this works is each state, and in California, the state treasurer's office, California State Treasurer's Office, remember the treasurer is an elected official, they allocate these tax credits to these housing developers who promise to offer low, below market rate rents, and meaning if the median rent is $1,800 a month, it's a little more complicated than this, keep in mind, then the affordable housing entity is going to offer those rents for less. And it's really much more complicated than that because those tax credits have a feature of the entity that owns them can use these tax credits retroactively or save them for the future or use them now. And they are also tradable, and they are traded on the SEC stock exchange. So, they're actually probably worth more than the housing itself, the ability to have these tax credits. And in this country, they're worth billions of dollars in any single given year. And that seems to be the important incentive to these folks who develop this so-called affordable housing. I don't think it's affordable because those rents change all the time. And, determining median rents could be argued as being pretty arbitrary. I'm talking to people who, I talked to a guy the other day whose income was SSI, disabled guy, permanently disabled, so his income is around $1,200 a month, and his rent in one of these affordable housing units just went up just a tad under $1,000 a month. I don't think that's affordable. Affordable housing has to be way below taking up that much of your income.
So they're not going off, they're not even looking at how much he's bringing in or how much he has. They just...
Well, they are to determine eligibility, but, and you would think, and this is where it gets complicated because these affordable housing developments have a whole, oftentimes you'll see brand new ones developed into multiple buildings, generally large complexes with 100 plus or more units. And often the developer will determine, okay, in this one building, the people eligible to live in these units in this building are going to be people that make 30% of the median income in that particular county or location in California. And another building, here's somebody that's 50% of the median income. And yet another building may be, 60%. Anyway, this is going to have different kinds of incomes living. And you're also hearing about these so-called affordable units that are mixed income. Okay, we're going to mix up folks who can afford to pay the fair market value out there, the big old rents, the expensive rents, and we're going to have them mixed in with moderate income folks and people that don't make any money at all. Because conceivably, you could have no income and live in one of these units. But these affordable property groups, I'm running into this situation now, where you've got a person that applies that's really low income, and they have a program through the treasurer's office. They're getting these tax allocations, and the person is more than eligible. They have very little income, and then they don't get rent. They don't get the unit. They're otherwise eligible, but they decide, well, they don't have enough money to pay the power bills, the PG&E bills, so we're not going to rent to you. So this is another tool to, even in housing that's developed for these groups of people, to, discriminate against them, not rent to them.
That's deep.
Well, this is what's happening. Under the Section 8 Housing Choice Program, I run into people that have, their HAP allocation, or their portion of the rent that they have to pay, sometimes is zero. And their housing authority is paying the rest of the rent. And then the landlord wants to know, well, how are you going to pay the PG&E bill? I'm not going to rent to you. Yet another tool. And Section 8 people can also apply with these tax credit communities, these tax credit apartment complexes. And so not only do they have to, bring in all their paperwork for the Section 8 program, but they're going to have to go through the eligibility, which is going to be, it should be similar, it kind of is and kind of isn't, to live in the tax credit department. So the general public, people like Mike and I, we're listening to this stuff and reading about it and talking to folks about it all the time. The general public out there, no matter what your income is, this is all, gobbledygook. What in the world does that mean? And so what you will get in terms of complaints from folks who are having trouble getting into this affordable housing because of their criminal background or their credit or whatever, or we don't make enough money, I'm getting the runaround. I had a call like that today. I'm getting the runaround. This guy applies for an apartment to just be on a waiting list a year ago, and it's here in Fresno. And so 2 or 3 weeks ago, he gets a call, hey, we've got a unit available, you have to come down and get eligible. And this guy is having a real problem. He has a criminal background. He is trying to get, he has one source of income, which is Social Security, disability. He's a senior citizen, but he's got some felonies and misdemeanors in his background. He's bringing in all the paperwork, and a whole year I've been waiting to, move into this apartment. And now they're giving me the runaround because they're going to keep asking for these documents that are going to satisfy their eligibility need. And what happens with the guys that create this affordable housing or develop it or build it, a lot of times they don't have anything to do with who's going to live there or the day-to-day operations. So they'll contract with a property management company. And a lot of these property management companies, not just here but all over the country, have developed their own kind of applications and software or software applications to help them determine eligibility of prospective tenants. And a lot of times they're not really transparent in the process, and people don't understand, well, how come I don't have an apartment yet? Right. I came in with a deposit, I'm poor, here's my source of income, and I mean, it's becoming a real bone of contention because the property management is speaking this language over here that's, totally involved with property management, and here's just a guy on the street that wants an affordable place to live, and you're really not explaining to him how the process works. And that may be due to poor training of the folks that are the leasing agents and that kind of thing. A lot of times we'll call at the Fair Housing Council these providers and ask them, hey, what in the world are you doing here? And they'll, let the guy in, which is kind of cool when that happens. Guy's eligible, well, why isn't he living there? How long do you expect people to wait to get into an apartment?
If someone's looking for housing, that's an emergency.
Well, of course, anybody that's looking for housing, that's an emergency.
Yes.
So basically, if you're running into problems with, and if you even know if it's supposed to be affordable housing, you need to call us at the Fair Housing Council.
What's that number again?
That would be in Fresno, 559-244-2950. We have a toll-free number. Most people don't need it anymore. But that toll-free number within the state of California is 1-888-498-FAIR, F-A-I-R. And we certainly welcome any questions or any problems that anybody out there might be encountering in terms of their inability to get a place to live. Maybe part of this problem that we see, homeless folks, which, we're given different names to, unhoused, presently unhoused, that's one of my favorites I hear. What in the world does that mean? Homeless means you don't have a place to live, okay? And maybe part of the problem is kind of the red tape involved these days. Oh, we got to do a criminal background check, we got to do a credit check, and then if it's affordable housing or subsidized housing, we need this eligibility document and that eligibility document. And sometimes what it boils down to is being poor and trying to get something to help you out of the being poor is a full-time job in and of itself. Running around, getting documents over and over again, and then, these same affordable housing complexes make you do this every year. It's called recertification. Section 8 has always done that. We want to recertify that you're still eligible for this subsidy. The government loves that. Even though you're, 75 and you got an award letter that says you receive Social Security benefits, you still have to come up with that stuff every year. Any closing remarks as we end this?
I think we covered a
You
lot
think
today.
we did?
Yes,
Okay.
I think we covered a lot. I think the people, if they've been watching, they've learned a lot. You
I
got
hope
the
so.
number, and remember, fair housing is the law, and we got your back.
We try to have you back. Thanks again for tuning in.
Michael Smith,
MJ.
MJ.